permitted to utilize the bathroom in another unit.
He's living in a different unit. He hasn't paid on that. Basically a $13,000 balance.
Did you pay rent for the month of June?
No,
Did you pay rent for the month of July?
no, I didn't pay any rent except for the first month when we got there because they never fixed anything.
Let's go, and counsel, your appearance for the record, please.
Good morning, Your Honor. Sidney Katz on that point.
Okay, and Mr. McKenzie, your name for the record, please.
Stanley McKenzie.
Okay, so just typically you'll stand up when you address the court, okay?
McKenzie.
All right, thank you. And so, counsel, today's the date scheduled. The issue here is for non-payment of rent that Mr. McKenzie was relocated while the plaintiff was performing repairs on his original unit. Okay, so as I recall, Mr. McKenzie was in one unit, and which was which unit number, counsel?
Your Honor, that would be unit
201.
201, apartment 201.
Okay, and so then there were some repairs that needed to be made, correct?
Correct, Your Honor.
Okay, and so then from there, your client moved Mr. McKenzie to which unit? Same building, just a different floor, correct?
Correct.
Okay, what unit?
This one was apartment 101 in the same building. And that was only the bathroom that they were giving them access to.
I'm sorry, what?
They had contractors working on the bathroom. They basically said, because the bathroom is going to be down, you can utilize the bathroom in the unit 101. And there's one more job.
When did the repairs, when was the communication given to Mr. McKenzie that he could utilize the bathroom in unit 101?
Your Honor, that would be sometime around September the 12th, Your Honor.
Okay, is that accurate, sir?
Yes.
All right, please keep your hands out of your pockets. And was that permission given in writing or orally, counsel?
I believe it was orally, Your Honor. It was given by my client, and I've asked them if they have anything in writing, but they weren't able to locate anything in writing.
Okay, and so how long did the repairs on the bathroom in unit 201 take?
As far as I'm aware, it was supposed to be over that weekend that they were going to be doing the primary work. So
That wasn't my question, counsel. My question is, how long did the repairs take?
I'm guessing, Your Honor, probably a week.
You don't know that information from your client?
I don't know the exact specifics. I just know when it was supposed to have been completed by.
Well, supposed to and when with contractors are definitely two different things.
Yeah, Your Honor. Now there were some items that were punch list items that were not completed until after Mr. McKenzie moved out, which includes painting and just basic cleanup work.
In the bathroom or somewhere else? Basic cleanup work. What does that mean?
Debris, just items that were final punch list items, Your Honor.
Okay, counsel, let me just clarify something, right? I'm very much familiar with construction and punch list items and all that stuff. All right, you have a contractor that was repairing a bathroom, and then you are telling me that there was still basic cleanup work to be done and painting of the bathroom. Now, I imagine the bathroom isn't very large. So, and by very large, I mean like a walk-in bathroom, not a walk-in bathroom, but like a master bathroom type situation. It's an average bathroom, correct? All right. So, Mr. Katz, what were the repairs that were to be done in the bathroom?
There were some leaks, Your Honor.
Okay, leaks. toilet leak, shower leak, sink
Shower
leak?
leaks. There was some mudding, replacement of drywall, mudding, painting,
Okay, what else?
and then clean up.
Okay. So the leaks were repaired. Correct?
Correct.
And the drywall was replaced
Correct.
and mudded.
Correct. It has been mudded, but I might have been only after Mr. McKenzie.
Okay, Council, let me be very clear.
Oh, no,
While Mr. McKenzie was the tenant in that unit,
yes,
was the drywall replaced?
yes.
Was it taped?
I don't know if it was taped, if it was fined, Your Honor. That's the point. That's what I'm saying. Because I do have an invoice from the contractor dated 10/3 for the, which was the final on the rehanged tape and mud. So it's possible, I believe that the mudding was done and the taping was done. I don't think that they finalized the painting until after Mr. McKenzie moved out.
Okay, so the only items that were being repaired for Mr. McKenzie was the bathroom.
Yes.
There weren't any other items in the apartment that were to be worked on.
Not that I'm aware of.
Mr. McKenzie, were there any other repairs that were to be made in the apartment other than the bathroom? Yes or no?
Yes.
Where?
The washer and dryer is located in the bathroom because there's a little wall that divides it. The washer and dryer was ruined from the leak, so they had to take it out and get a new one because the water went into the back of it and shortened it up.
Okay, so the washer and dryer were to be replaced.
Yes.
Is that accurate, Council?
I don't know if they were to be replaced, but I know that it was in the bathroom, as Mr. McKenzie indicates. So all the work that was to be done was in the bathroom. Eric.
Okay, so Mr. McKenzie, was there any other work in the living room, the kitchen, the bathroom, otherwise that the bedroom that was to be repaired, or only the bathroom?
The bathroom is where all of the problems were.
My question is, sir,
Yes.
were there any other rooms in the apartment?
No.
Okay,
I have a,
hold on, sir. When were the repairs set to take place?
Is that for me or Mr. McKenzie?
Either one.
I believe the week of September the 12th. September the 12th was a Friday. And so they basically had the contractors who were supposed to be out there that weekend. So they told Mr. McKenzie he can utilize the bathroom in the unit below. And that was the weekend that they were supposed to be doing the work, which is when I believe they did the work.
Okay, sir,
uh,
was there a conversation that you were permitted to utilize the bathroom in another unit while your bathroom was under construction?
yes.
Yes or no?
Yes.
Okay, very good. And so would that be accurate, September 12th?
September 12th is just when they got there. Well, they were supposed to start right after we left here when we saw each other last, and they did not start until 2 weeks later.
Saw each other last. You're
When we
here,
came into the court.
you're here November 10th.
No, I mean, back then, the last time that we came in here before that, I'm sorry.
Okay, so,
And they didn't start until 2 weeks later. They came and cut a hole in our ceiling and left it there
in the bathroom.
in the bathroom.
Okay, so pause just for a moment. So was that September 12th or not?
No, when they cut the hole, no.
When was the hole cut?
The hole was cut probably the week before that. I'm sorry, 2 weeks before that. Actually, when is the last time we were here? I don't know the exact date when we were here, when you told them that they have to do the repairs for the third time. They came in after that and cut a hole in our ceiling and just didn't come back for 3 weeks. And then when the videos that I showed him on the 11th is when they came back and started. And he just said that was right. The 12th, they they had already ripped down the ceiling and the walls and pulled out the machine, the washer and dryer. As he saw, once they cut the hole over the shower, that was where the biggest hole was from the leak. But they left it, they never came back. And that was different people. I guess they quit or got fired or whatever. 2 new guys came on the 11th, and they are the ones who tried to cut into where they were, the last hole, and realized that the whole ceiling was rotted and the walls were rotted. And the back of the machine had rust and all the water. When they moved the machine out, the water just spilled. I think I was on video with you when I told you the first time the water splashed on me.
Okay.
The time when it splashed on them, it came over.
Okay, just a moment. Mr. Katz. Are you familiar with that?
I'm not familiar, but Your Honor, I do have to ask a procedural issue because here's where I'm sort of confused is it relates to this. Assume you gave him 100% abatement on his old unit, okay? 100% abatement on his old unit. He's living in a different unit. He hasn't paid on that unit. If he pays the $5,200 my client is claiming that we're here for, okay? Remember, he said he was going to put money in escrow 4 times in court with the prior hearing. No money has ever been put in escrow with the court. If he got full abatement on the prior unit, okay, which I don't think he's entitled to, but let's say he did, he hasn't made any payments on the existing unit. If he pays on this case for the existing unit, which he has no issues with, Your Honor, then he could stay in his current unit technically by law because we filed this as a non-payment as opposed to a termination of tenancy.
Okay, so just a moment. Sir, you're living in 101, correct? You moved all of your items to 101.
Yes.
Okay. Have you made a rent payment?
No.
Why not?
Because we were told that we were only going there because of repairs that were being done.
Hold on.
First,
Listen. When is the last time you made a rent payment, sir?
I haven't paid rent since we moved in
Why not?
because of everything that we're here for. The bathroom is completely ruined.
Hold on.
There's nothing.
The current bathroom that you moved into?
The current bathroom that we moved into is absolutely rotted, just as the one we were in before.
So, sir, so tell me, okay, you haven't paid rent to your landlord. What escrow account is your rent in?
I had an escrow account as we came here the first time. And I told them that. And we were thinking that they were going to get everything finished. Once we realized that after 2 months, nobody had come in.
Sir, you're not answering my question.
I had
Where's proof of the money in escrow?
the proof of the money in the escrow is in my account.
Great. You need to show where that rent money is sitting.
The rent money is still sitting there.
Great.
Because we were about to move.
Pull up your bank account. Pull up your bank account.
I can't pull up
Your
my
Honor,
bank account.
I
I can go and get a statement, which is what I was supposed to be talking to him about. You told us, you said, we won't even have to come back here if you two come to an agreement about when moving in or if you're gonna get paid. I told him that I was gonna be out of there by the 1st. He said, okay, if all you have to do, if you don't pay us, then you have to be out. I said, yes, we plan on moving on the 1st. We couldn't move on the 1st.
1st of November?
It was October. We couldn't move on the 1st because we got after you gave them the default victory, we got a eviction notice. We go back to the place where we're about to move into. The lady says, no, you have an eviction notice. You can't move in.
Sir, you've now been living in a spot that you are living in and you haven't paid rent.
I'm not paying rent for something that these people ain't never fixed. In the house that we in now, it's still rotting.
Okay, then sir, you are required by law to show proof as to the money being in an escrow account, a separate account or otherwise. You have yet to show that proof. How much money do you have set in that separate account?
The separate account is $7,000.
Your Honor, if I can.
We were about to get it shown.
When we were here in August, you asked to send me, you said he has to send me a copy of his escrow account. He didn't. We spoke in court the next time. You said, send him a copy of the escrow. He didn't. I sent him an email on September 12th. I followed up on my conversation with.
Excuse me, just one moment. Did you respond to the email?
He didn't send me any-
Excuse me, let me finish my question. Did you send a response to Mr. Katz's email with proof of the rent money sitting in a separate account?
I just said no,
Okay,
because he didn't send me an email that you can't respond to something that no.
all right, counsel, I'll take a look at that email. First, you have to
I'll
show,
show it to Mr.
well, no, my court officer will do that, thank you. Thank you. Do you, okay, but there was another one filed in August.
Are you on it on my phone?
Nope, I'm on this current one.
Okay.
So you should be able to get it out of the other one if you could.
Okay.
Yeah, thank you. It's the one that ends in 946, sir?
That's one of my emails, yeah.
How
I didn't
many,
get that email.
how many emails do you
I
have?
have two.
Okay, when you say you didn't get it, what does that mean?
I didn't receive that email.
Did you check your email?
No, I didn't check it. I never knew he sent it.
Well, sir, it's your responsibility to check your emails.
No, I mean, I checked my emails and I didn't see nothing from you.
Good.
You know,
Pull up, grab your phone, grab your email. Terry, can you please watch him pull up his email with this one to look back on September 12th, please?
And Your Honor, I did follow up with a call to him. I tried to call him multiple times.
All right, just a moment, counsel.
We spoke one time on the phone.
We're right now, we're just gonna have you look for your email from that email address on September 12th.
And Your Honor, just for the court's record, Mr. McKenzie.
Hold on, counsel, please.
Here's the email from me. He said he sent it on September 12th, right?
Yes. 2:37 PM. Is that the one that ends in 946?
Mhm.
Is it showing on there?
It's buffering to get to.
Okay, what else is it you wanted the court to know, counsel?
So Your Honor, again, Mr. McKenzie was informed at least, I think, 3 or 4 times with the court to present the court with the copies of the escrow and to present me with copies of the escrow. He never did as it relates to this prior case. He has yet to show any evidence, and he's had ample opportunity from August of this year. In addition, he was moved out of his unit with an $8,700 balance on his prior unit. So on top of the fact that he now owes over $5,000 on the current unit, he's been living, has basically a $13,000 balance with my client.
All right, counsel, just one moment. What the balance for unit 201 was how much?
$8,680 was the final balance.
Okay, final balance. What does that represent? How many months of unpaid? How much is the rent per month?
The rent per month is $1,499. There's additional charges of trash, gas, pest control, water, which total around $120 to $130, it looks like, per month. And then they actually prorated him through the date that he was actually evicted out of that prior unit, 10/6/2025. So his only payments, he moved in on April the 30th. The entire time he was there, his payments equaled $1,613.72.
Okay, so that's how much has been paid since he moved in on April 30th, correct?
Correct, except for an application deposit of $150.
Okay, so let me ask this question, counsel. $8,680, that's $14.99 per month in rent plus the $130 per month in extras. That's for May. No, that's for June, July, August, September. When you say final balance, what else is on that final balance?
There's no damage included on this that I see. There's late fees each month for non-payment, so.
How much are the late fees?
$100, so $500 of late fees, it looks like. And
$100 per month in late fees?
They started in September and in October, so it would be 6 months of late fees. And then violent.
Well, so if he moved in April 30th and he paid a month of rent, that would be for the month of May, correct?
Correct.
All right, so June, July, August, September, that's 4 months. So 1629, which is the $14.99 rent plus the $130 in extras for 4 months is $6,516. Plus 4 months of late fees is $400. So
6 months of late fees for,
council, right now I'm just going on unit 201 right now. I'm going June through September. Because June, July, August, September. So that's $6,916. And you said then there was a prorated amount for October for 6 days?
correct, so it looks like, oh, actually, they did not, they actually recharged it, so actually the whole month of October is in there. See, they originally broke it,
Okay.
and they put it back in.
Okay,
So that would account for that difference.
all right, that would, plus the $100 late fee. Okay. All right, so. Mr. Mackenzie, did you pay rent for the month of June? Are you on your phone, sir? Or are you still looking for the email?
I'm looking for this email that don't exist.
Well, it exists, sir. Whether or not you received it is my question. That's why I wanted you to show my court officer there, but I don't know if it's continuing to buffer. What date are you on?
We only back 4 days.
Oh, okay. Well,
But
sir, let me ask this question.
Both.
Let me ask you, I'm not questioning whether it's buffering. Okay, please keep your hands out of your pockets. Did you pay rent for the month of June?
I paid rent when we first moved in.
Did you pay rent for the month of June?
No,
Did you pay rent for the month of July?
no, I didn't pay any rent except for the first month when we got there because they never fixed anything.
Okay, so, sir, it is your responsibility per the law to show the court and your landlord that you are depositing the rent in a separate account. That is what the law requires.
Yes.
You have not done that. I'm not questioning whether or not the repairs were necessary or not. They clearly were necessary because they were made. They were made. You did not submit proof of the escrow amount as you are required to do.
And they didn't fix anything as you told
Sir.
me they were required to do.
Sir, just let me,
Yes, sorry.
they did not fix what they were supposed to do. They finally did it in September. That does not negate your responsibility for showing proof that the money is deposited in a separate account. Had you done that, we wouldn't even be here. Because you have that requirement. It's a legal requirement that legally allows you to withhold payment of rent for repair issues. You did not submit proof of that. And the court will also note that July 25th, on the prior case, 2501234 LT, that you claimed many repair issues. We set it for a second hearing August 11th at 8:30. On August 11th, there is no agreement on the amount owed. Plaintiff claimed $51.51 was owed. We set it for an in-person hearing August 22nd at 11 a.m. The court also on August 22nd stated that there was a hearing, there was information gathered. Parties were to return September 15th at 11 a.m. Defendant to be included in any communication regarding scheduling to look at the apartment and repairs to occur. Defendant to submit proof of rent money held in account and activity of deposits by August 27th. Did you do that?
And
Okay. Then on September 5th, and everybody was supposed to return September 15th. Oh, sorry. Also on August 22nd, Gold Star Restoration was to be at the apartment that day between 12 and 5, and the court had ordered the parties to go in the lobby to determine if they'd already been dispatched to the apartment, because I recall that that was a concern that had occurred. Now, then let's move to September 15th. Mr. McKenzie, you were not present. Also, you had not shown proof of the money escrowed by August 27th. The representation on September 15th was that all repairs have been made and near completion. Drywall being completed September 16th. That's when the court entered a default judgment of $6,856 with a writ of September 25th. And the abatement was not addressed as you did not appear and you did not speak with plaintiff counsel regarding any abatement. Sir, had you appeared, the court would have known
That they didn't fit.
that it wasn't finished. Because the court took what counsel represented. Now, whether or not counsel spoke with their client ahead of time, I have no idea. The court has to go with the representation as an officer of the court that is all being done. Further, the court then, so there was a judgment entered appropriately. There was a judgment entered because you weren't here, sir. I don't know why you didn't show up, but you weren't here.
That's what I was talking about in the last Zoom. I didn't show up because I had asked if we could change to another day. And you said no. And I said I had to work that day because I drive longer. So I couldn't be here because I was out of the state. And I remember saying that I was like, can we please do it another day on the Zoom? You said, how come we didn't do it on Zoom? And I said, I don't know why we didn't do it on Zoom. But you said we had to be here that day. And I couldn't make it that day. And I let you know I couldn't make it that day.
Sir, when did you send something in writing? Because listen, I have hundreds of people that speak to me in a day.
Oh, no, I didn't.
Hundreds of people that speak to me in a day. Okay. And so
I didn't.
while I have a fairly good memory and recollection of many things, I don't recall every single conversation with every single person. You were not here on that date. You didn't even Zoom in or anything. Okay. So the court entered a default judgment.
Right.
Clearly, there was a misrepresentation or misunderstanding somewhere because the repairs were not done as counsel represented they were.
I had talked to him.
In any event, sir, you did not show proof of the money deposited in escrow. Had there been proof submitted to plaintiff counsel would have been required to notify the court, show the court, and the court likely would not have entered a default judgment against you, sir. But that didn't happen. And now you're occupying another unit and not paying rent and not showing proof of that money sent into escrow. So, sir, let me also clarify something. Back in July and even August, I could have ordered you to submit that escrow deposit with the court. And if you didn't, then there would have been additional violations. Counsel, you on your phone?
I'm just checking the date, Your Honor, because
The date of what?
Your Honor, I'm almost certain that when we scheduled the date with Mr. McKenzie for that September, what was it, the 15th?
15.
You actually chose the date because Mr. McKenzie indicated what were the best dates for him. Okay?
I would agree. I'm pretty sure I did.
We modified the court dates specifically based on Mr. McKenzie's AM, PM, and whether he was working that date. So Mr. McKenzie says that he told the court that he wasn't available. I am certain, Your Honor, that on the date that we scheduled, it was scheduled with him in mind and with his schedule in mind.
I agree. I would agree with that because I was being very careful to make sure that Mr. McKenzie was able to be at these hearings.
I asked you about that day. I said, can we do any other day? And then you said no. Now, on the last Zoom we had, you said, how come we didn't Zoom? I Zoom when you say Zoom. I come in when you say come in. So if you didn't tell me to Zoom that day, it's because I don't know why. But I have certain days that I drive. That was a money day. So I absolutely know that I came to you and told you that before. Why would I miss that? There's no way that happened. So
Sir, let me just clarify. I do recall that when selecting these dates and times, the court did take into account your work schedule.
I know exactly why, because when I was going to show up to at home, every time they were supposed to come out and fix things, it never showed up. You said, you talked to them, how come they didn't show up? And I said, I've been missing days of work to stay home waiting for these people to show up, because that's when they said, we don't know when they show up. They just show up when they show up. That's literally what they said. And I said, I stay home from work and miss work waiting for these people and they never show up. And you tried to make an accommodation and I
Okay.
did everything.
All right.
I said, but that day is Mondays is a money day that hasn't changed in 4 years.
Sir. Okay. Irrespective of all of that, your legal requirement of showing the money deposited into a separate account has not been met. And further, I even ordered that you had to show proof of the deposits that had been made to show that every month you were depositing money into this account in lieu of paying rent. You did not do that.
So when
Sir, you did not do
I
that.
said, no, I didn't. You're right. And you told us that if we came to an agreement, that we wouldn't even have to come back here. I called him, told him that when we were going to be out, and he said, okay, just show me that thing that you just said, the paper. I said, fine. That day came for the 15th. I called him before that. Now, this is what we had a disagreement with outside in the lobby. On the day that I was calling, he had a message that says he wasn't returning calls or texts or something like that. I called the manager. She called and said, well, he's not answering available. Same message that I got. She said, I'll let you know. I'm going to call my boss.
Okay, sir, hold on just a moment, please. Just a moment. What date is all this occurring? This that you're talking about right now, what's the date?
Exact date.
Well, I need to know that because
It was-
from August 22nd until September 15th, I'll tell you I'm sorry?
It was between then, before the 15th. And this is the reason why I was saying that. The reason I called him to make this agreement is because I knew I was not going to be there on the 15th. That's why when he says, oh.
Sir, just one moment. Please listen to what I'm saying. There's 3.5 weeks in between the court dates.
Yes.
So in 3.5 weeks, you did not send that to Mr. Katz.
No, I didn't.
Okay. So, sir, that is the whole crux of the entirety of the case at this point. There is zero doubt that there were repairs that need to be made. The court also doesn't have any doubt that those repairs were made while you were the tenant of that property.
Yes, that never made while we were leaving.
Okay, and you never showed proof of your deposit,
Right.
which you are required to do.
Yes.
So therefore, the court doesn't have any legal basis to not grant the plaintiff's motion or the plaintiff's request for judgment, sir.
So if I was to bring it in or mail it to you or give it to him, to y'all both after this, what would that do? Would that make it to where my problem that I have now is that default judgment put an eviction on my record and I can't move into somewhere else because they see the eviction from this place when I should have been evicted, when they never fixed anything. My house is like construction.
Sir, then you should have followed the court order. You should have followed the court order and sent proof of that to Mr. Katz.
They didn't follow the court orders either.
Sir,
And I'm the only one getting punished.
sir, the property has now been repaired.
It's not.
The one, unit 201 is what I'm talking about.
They still
201 appears and is represented to have been repaired. Now, if you wanted this court to take into account abatement amounts, as it was going to do, then you needed to submit proof of the deposits of the rent to Mr. Katz. You did not do that. And in fact, the court ordered that on August 22nd, sir. August 22nd, the court ordered that. You did not do that. You did not do that in August, September, October. And now here we are, November 14th, for an in-person hearing, and you don't have the documentation with you yet again today. So, sir, while the plaintiff's potential for having a violation of a lease for not repairing the items, that's a separate issue as well. What we're here for, sir, is that you did not pay rent. You did not show proof of your unpaid rent being deposited into a separate account. That is how you are legally able to not be responsible or not be evicted for that purpose. You did not do that. 4 months. 4 months, you have not done that. So, sir, that is why this court has to enter a judgment against you for non-payment of rent. Because at this point, it's the plaintiff's inability to repair their units timely is not as much of an issue at this point because you did not show the proof of the escrow accounts. And that, as I stated, is the only way that you can legally withhold rent. And that did not happen. And sir, there were multiple opportunities for that to have been shown.
You're right. Thank you for giving me those opportunities, and I didn't show it to you, and I was upset, and I'm still upset, and I wasn't going to. I should have brought it to you, like you said. I'm sorry about that.
Now, sir, let me also be very clear that because there's judgment that's going to be entered against you doesn't mean that this court doesn't have concerns about the plaintiff having things repaired timely. Okay, that is not the case. But as I stated, the only way that this court could not rule in favor of the plaintiff is had you shown that. So the court is going to enter judgment for plaintiff.
And your energy house. Because the old balance is irrelevant. My client would have to file a separate case.
So this is only for October?
This is for actually October and November for the current unit, which they indicated to him. They posted the amount he would have to pay if he remained in that unit. The monthly rate on that unit is $2,500. So he owes $5,000.
The monthly rate is $2,500? Hold on, just one moment. Counsel, how is it $2,500 when the unit right above it is $1,499?
Because he has no lease, Your Honor, and basically he was not provided access to that unit other than the bathroom. So there was a notice that was put on his door that said, if you remain in this unit, you will be obligated for $2,500.
Okay, can I see that notice, please?
And I showed it to
Terry, can you grab that, please?
Yeah.
He saw it.
Well, hold on a moment, counsel. When did the new tenants move into 201?
The new move into 201. I actually have the date of that. 10/27.
October 27th.
Correct.
And I believe your statement was that the bathroom wasn't completely finished until after the new tenants moved in, correct?
No, until after they moved out of the final painting and final work and cleanup of the unit was done after October the 6th, Your Honor.
Okay, well, counsel, I'm not going to authorize $2,500 per month because this states, this notice is to inform you that the temporary use of apartment 101, which was granted solely for bathroom access during the restoration of the bathroom in apartment 201, is no longer authorized. As of today, the bathroom in unit 201 has been fully restored and is fully functional. It was not fully restored. Not by a long shot was it fully restored. So this is not, the court's not going to authorize $2,500 a month. So the court will go on the same rent as it was in 201, which is $1,499 a month plus the $130 a month in extras, correct?
Correct. Plus the late fees since they're paid.
So $1,629 times 2 months is $3,258 plus the late fees of $200. $34.58. Correct, council?
Yes, cost of 180.
$180 for court costs.
It's 38.
$3,638 is the amount, the judgment.
Your Honor, the stuff that was supposed to be fixed upstairs at our old unit is still not fixed because the water is still leaking down to where we are now. And I wouldn't say nothing about it if it wasn't that I called Riverview Housing Department because they had to come do an inspection because there is mold.
Did you submit that in writing to the plaintiff?
Oh, no, those are the videos he just saw. And
Did you submit, sir?
I didn't write nobody, but I did.
I believe in your lease, if you look at your lease, you need to submit repair requests in writing. I would presume. I think that's typical of any lease, but I don't know this particular one. So I understand you may make a phone call.
Yeah.
But
So then they do the thing. Or ticket, they call it.
emailing is probably the most effective way to make sure that there is a chain of communication. But again, sir, you haven't put any money into escrow. So even if you notified them on the new unit that you moved into that there was a repair issue, you are still required, if you're withholding rent, you are required to notify them you're withholding rent and proof of the escrow account, right?
Yes.
And that didn't happen.
Yes.
I'm already not assessing the $2,500 per month because that was a misrepresentation. The unit was not fully restored. And nor was it anywhere close to being done when the parties were here back on September 15th, indicating all repairs have been made and near completion, drywall being completed tomorrow. So apparently near completion is a subjective definition. Because counsel, let me be very clear. Had I been informed properly that the repairs were not all finished and not near completion, it may have been slightly different. So as counsel for the plaintiff, it's your responsibility, counsel, to communicate with your client to get specific information. This court requires details, specific information. Even as simple as having the names of your witnesses to tell the court. The court's going to order, after hearing that the judgment is for the plaintiff, $3,638. If the amount is not paid, defendant does not move out on or before November 24th, plaintiff will apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant. No money judgment at this time. Good luck to you both. We'll make sure you get those back, sir.
Your Honor, do you want the copy of the judgment or do you want me to just submit it in my file?
You can submit it via my file. Thank you. Good luck to you both.
Enjoy Mr. Borkin. He's handling what's messed up.
Yes. What's that?
Sorry for getting upset.
That's fine. You're fine.
Sorry.
Oh, you're fine. Thank you. All right, let's go off the record for a moment.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands. You take it to court.
All right, thank you very much. Officer Brell's waiting for you, and that will bring this case to a conclusion.